Donaldson. I am the director of the Washington office of the ILO, and I get to be the formal ILO presence here today as our governing body is meeting in Geneva. And so I'd just like to say thank you so much to the panelists, to participants who are dedicating this day here. I see some of my colleagues, George Magnich, our former executive director of Social Dialogue, is here, and my colleagues from so many agencies, and it's wonderful to have you here. And what we're looking forward to is actually a serious discussion, serious questions, and ideas from the audience, not just panelists presenting. Our panelists are interested in what you have to say or what your thoughts are. We have a wonderful array of speakers, so I do urge you to take a look at the bios, because we're not going to take the time to go into all biographical background, but we have the top of the pile here. So I'd just like to thank the Catholic University of America Columbus Law School, and it's my pleasure to both welcome you and to introduce Dean Miles, who has been at the helm of the ship here for a little while, or for quite a while, and she may tell you she's going back to teaching because of her love of teaching, and it's just nice to know you can do that. You can take an administrative, a senior manager level like a dean and still teach and have that be part of your life. So you're a real inspiration to people like me. And thank you very much for having us here.
Good morning, everyone, and welcome to the Catholic University of America. I'm just so delighted that we're able to co-host today's program with the ILO. This is a thrill for us. About a year or so ago, Karen Tramontano, who is one of our alums, met with me and said, you know, we'd like to do a program here in Washington. And I was thinking it would be great to bring it back to our alma mater. And I said, wow, this would be fantastic. And as a result of her request and identifying several colleagues on the faculty, Shelby Quast and John Higgins, who assisted in the organization, here we are today. And I want to thank them for their work, and most importantly, I want to thank all of you for taking time out of your day to be a part of the program and this very important discussion. You know, the idea of looking globally to find authorities to help us with very important issues such as healthcare, integrated military operations, or the issue that we're going to be dealing with today. What are the best practices in terms of international labor standards is such an important conversation, and obviously one that is ongoing and growing even more and more as our world becomes a smaller world, and I think that makes it a better world in so many ways, and we can learn so much from one another. So I'm delighted that we could host this conversation, which I know will be a very critical piece of an ongoing discussion, and I thank you for being a part of the program. I want to thank all of the panelists for agreeing to be a part of the program, and as I understand, the audience will be a very important extension of the richness of this program, and I thank you again for being here. Our keynote address will be given by the Honorable Peter Mazzetti, and I want to tell you that he is a part of our CUA family. He has been at Catholic several times to participate in some of our international programs. We have a program that involves Portugal, our Lisbon project, and the judge has participated in programs that we have had here, and he just shared with me that he recently enjoyed a Fulbright in Portugal as a result of some of the work that he's done with us. He is a member of our family here at Catholic, and it is such a privilege and an honor to always welcome him here to our community. And as Nancy has indicated, we do have a brief bio regarding his background in the program, and I would ask all of you to take a look at that and appreciate the richness of his experience, because you are about to enjoy the richness of his ideas. Judge Mazzetti, thank you.
Nancy Donaldson, Dean Miles, ladies and gentlemen, nice to be with you this morning. Thank you for the kind introduction. I must say I greatly admire the ILO for the work that it has done over so many years to improve the lot of working men and women around the world. And to be asked to keynote this conference is really quite an honor. Dean Miles referred to the biographical note. You'll see the last line in there says that I was awarded in Brazil the Grand Cross of St. Joseph the Worker. And I don't know why I was, but the interesting thing that I recollect of that is when I gave my speech and was awarded the Grand Cross, I was wearing one brown shoe and one black shoe. And afterwards, the first question from the reporter was, does that have something to do with your message? And I said, my wife was mortified, and I said, it doesn't. Today, I think my shoes are the same color, and I'll try and give you a consistent statement this morning about where I am. I'm not going to talk to you today about why international labor standards are a good thing or what ILO should do to get more countries to sign your conventions and comply with them. What I am going to talk about is something which I think is considerably more limited, but I hope no less interesting to you, and that is how is a U.S. district judge, how is that person apt to view international labor standards when they come to court? And to what extent will those standards be likely to enter into and influence the thinking of a federal district judge in this country? It's really very much the fourth question that I think you have on your questions, which what are the concerns that you should have as you ask judges to apply international legal standards? Let me acknowledge first that I have been preceded on this topic by some genuine heavyweight keynoters in the past, not necessarily here but in other forums. Justice Sandra Day O'Connor spoke to the American Society of International Law in 2002. Justice Stephen Breyer talked to that same organization in 2003. Specifically with reference to international labor standards, Judge Rosemary Barquette of the United States Court of Appeals for the Ninth Circuit spoke at a seminar sponsored by Stanford Law School in 2009, and I had some correspondence with her as I prepared for my remarks this morning. And it's fair to say, I think, that all three of these very distinguished individuals approached this topic with great humility. Justice O'Connor, for example, and I think you may have this in your materials, but if not, I'll repeat. When she addressed the American Society of International Law, she said, I do not know much about international law. I am just learning, she said. I really do feel like a fish out of water in speaking to a group of international law experts in light of my own limited knowledge. American courts have not developed a as robust a transnational law as they might. And then Justice Breyer and Judge Barquette were equally cautious about their experience in the field, although to be sure they were affirming that American judges are becoming increasingly aware of their responsibilities with respect to not only domestic law but the law of nations. I don't want to part company from this distinguished crowd. I hope to be equally humble. I want to confess my own limited experience in the area of international labor standards and perhaps even in the field of international law in general. But the truth is, I am a federal district judge. I exercise general jurisdiction in my activities, and so and I don't have specialized labor knowledge or exercise jurisdiction as a labor court, as of course happens in many countries, including countries that I've been to. So I do have some experience as a generalist, and I must be ready to deal with any such issues that may come up along the way, regardless of their novelty. Even though, as I say, I'm limited, and that, of course, includes international labor standards. So let's imagine a case in which one party or another wishes to come to my court, a federal court, either directly or indirectly, and wishes to introduce the concept of an international labor standard or standards. What would I or any federal judge want to know, first of all? Well, I spent a considerable time preparing for this morning by reading a lot of material to prepare, which is another way of saying that I think the judges would want to spend a fair amount of time learning about the context the history and the current setting in which these standards have functioned and the way in which they continue to function. In fact, I suspect they would want to know just what the ILO is. I don't know that every judge would know for sure that the ILO is a product originally of the League of Nations and the Treaty of Versailles after World War I, or that it is an arm of the United Nations today with some 180 plus members. Most people don't know that. They could easily be confused with the Second Internationale or the International Workers of the World. So we need to sort of get oriented even in the fundamentals as to that. So lesson number one is don't assume that your federal judge carries around in his or her head the vast amount of knowledge that most of you have about international law and international labor law. Be prepared to educate your judge in the fundamentals of dealing with international labor standards, both in general and then in the specifics of international labor standards. All right, suppose you've told us about international labor standards and how they work, and let's say there's attention drawn even to the ILO Declaration of Fundamental Principles and Rights at work, the core principles, the right of association and collective bargaining to the extent that relates, forced labor, discrimination in employment, or exploitation of child labor. What next would be my concern, or really the concern of any federal judge? Well, it would, I think, essentially be this. The question that the judge would ask himself or herself would be, just how do these standards relate to American law? How do they relate to the United States Constitution? How do they relate to federal statutes, to agency regulations, to executive orders, or indeed to private agreements? That's the thinking I would go through, and I suspect most of my colleagues would. Because, as you know, we're not about to openly walk about and say, oh, international labor standard, let me have it. Let me put it to work in this case. We want to tie it to some species of more solid American law, some positive law. You know, it's long been a criticism of courts, federal and state, and of judges, that they are too activist. And why I think this charge is probably less well-founded than some would say. But there is that sentiment out there. I mean, both liberal judges are charged with being activists nowadays, conservative judges as well. And there's that kind of ambience, if you will, that a federal judge functions in. Don't want to be too activist. Some sharp-tongued people out there, they're apt to come down hard on me if I am too openly embracing of some international standard. Just think back to the International Workers of the World. Additionally, you know, a debate has grown up in recent years about the extent to which it is proper, if at all, for U.S. courts to look at either foreign law or foreign standards. Justice Scalia is closely associated with that view, with the naysayers. He doesn't think that foreign law should be looked at except in extreme contexts, such as treaties. He doesn't like to look at foreign law as a source of orientation or inspiration. Some people think he created this whole issue himself out of whole cloth. In fairness, as I say to him, he does acknowledge that international law applies in treaty contexts and a few other limited contexts. But his view, in my opinion, is really not widely shared by American judges, even though some congressmen and perhaps even some law professors might be in agreement. I don't think that people believe that you can never look to foreign law or foreign standards because somehow it's antithetical to the American experience. If you go back to the Declaration of Independence, we talk about a decent respect for the ideas of mankind. If you go back to the early case of the Paquete Habana, there's a statement to the effect that international law is part of our law. It must be ascertained and administered by the courts of justice of appropriate jurisdictions, as often as questions of right depending upon it are duly presented for their determination. Even so, some judges may well be intimidated, or at least, to tone the word down a bit, cautious about over this debate, that they are not going to be openly disposed to embracing foreign law and international standards. We live in that environment. I mean, recall, if you will, the grilling that Justice Sotomayor received during her confirmation. They talked a lot about this foreign law concept, which in my view is largely a bogus concept, but they still talked a lot about it. So judges hear that, and they wonder the extent to which that's going to affect their decisions. We're vain like everybody else. Some of us have ambition to climb and so on. You don't want to be too extreme in your views. All right. These constraints aside, I also want to say that there's an inherent conservatism that surrounds federal judges, in particular, all judges, but federal judges in particular, and most of you as lawyers will understand that. We only hear actual cases and controversies. We don't give hypothetical decisions, which in many countries are given. You can go to the president of the country or some member of the leadership of the legislature can go and get an advisory opinion about the effect of a law. Well, we can't do that here. It feels like we're doing that with the Affordable Care Act right now, but for the most part, we can't do that. We have to wait until an actual case or controversy arises. Only people who have directly suffered injury, in fact, have standing to raise the issue. Not just anybody. It's got to be somebody who's got direct injury. We are bound by precedent from higher courts, so we don't feel as trial court judges, judges of first instance, or even indeed courts of appeal to simply go out and openly embrace the standard. We have to work within that framework as well. And of course, we're told, decide the case on the narrowest possible grounds. Avoid constitutional issues if you can. And you know, when you talk about international labor standards and fundamental rights, you're getting close to constitutional issues. Well, we're supposed to be careful about that. We're not supposed to decide cases on those grounds if we can avoid it. And of course, the whole idea of dicta. Better not to pronounce largely on issues that aren't before you. This is all what hems about a judge when you come to bring to the judge the concept of an international labor standard. And let's face it, you know, the task is difficult enough to begin with. As Judge Barquette of the Ninth Circuit said in her speech to Stanford in 2009, judges face a difficulty interpreting the language of rights, entitlements, or standards, and specifically the observation that language used can be too broad to be easily enforceable, at least in a court of law. Those are the kinds of things that also we have to confront as judges. And of course, let's take the case now that's before the Supreme Court, the Kiobel versus Royal Dutch Petroleum. The initial question that was certified for review was whether a corporation could be sued in U.S. courts under the Alien Tort Claims Act for purported complicity in torture that was perpetrated in another country, I think Nigeria. Recently, the court asked the parties to expand the issue and to address the larger issue of whether anyone, corporation or otherwise, could be sued for alleged human rights violations in American courts. And during oral argument, Justice Alito is reported to have said, "What business does a case like this have in the courts of the United States? There's no connection to the United States whatsoever." That's Justice Alito's. And in fact, the parties were asked to rebrief it and re-argue the case next term. Those of you who remember the outcome of Citizens United, that was a case where they had a limited issue and the court asked the parties to rebrief it, and they came back with a blockbuster. Be prepared. I don't know what the outcome will be, but that's the kind of thing that is going on right now, and all that is part of the environment in which we as lower court judges find ourselves, that there's that attitude. All this said, do not despair. There are still many ways in which international labor standards may yet influence the thinking of federal district judges, and that's true whether we're talking about whether these international constraints are taken into account or not. Remember that while the United States has not ratified all the conventions of the ILO, it does acknowledge the more general language that one finds in the Declaration on Fundamental Rights, Principles and Rights at Work, and of course the Universal Declaration of Human Rights, those concepts that talk about a minimum, general anyway, standards of the workplace. And as Judge Richard Posner, one of the leading legal thinkers in the country today, wrote in the Floma versus Firestone Natural Rubber Company case, the fact that Congress may not have enacted legislation implementing a particular treaty or convention, maybe because the treaty or convention hadn't been ratified, does not make a principle of customary international law of evidence by the treaty or convention unenforceable in U.S. courts. It may yet be evidence, and so there is that to bear in mind. Our law, our domestic law, paralleling the core conventions, has undoubtedly influenced the formulation of those core conventions in many respects, even though most of the conventions remain unratified by the United States. I think we ratified the abolition of forced labor and worse forms of child labor conventions, but others have not been ratified. But Samuel Gompers, who was the president of the AFL at the time of the creation of the forerunner of the ILO, was chairman of the Commission on International Labor Legislation, authorized by the Paris Peace Conference in 1918. He set the agenda for the charter that proposed the creation of an international labor body, which, as I say, became the ILO in time. And he was in favor, obviously, of recognizing rights that protected workers, including, among other things, the freedom of association. So that goes way back then. This is American law influencing the international standards. And of course, as you are well aware, better than I, we recognize multiple rights of workers in terms of their rights to associate and engage in collective bargaining under the National Labor Relations Act of 1935. We have laws which protect against discrimination in employment with regard to the hiring, firing, discipline, and promotion, whether it's based on race, color, religion, national origin, gender, age, and disability, the Civil Rights Act of 1964, etc. We punish cases of involuntary servitude. It's not always a civil case that's brought. I had a case not too long ago where a Nigerian doctor who came to this country had brought up basically a young woman that they kept in slavery in the basement. She was promised the right to go to school and be raised as a child, and in fact she lived in the basement, received no wage, was occasionally mistreated. Unfortunately, she was sexually abused by the husband. That case came to trial in the U.S. District Court for the District of Maryland, and that judge is now doing 7 years in a prison in Texas. So there is that sense of American law that comes at some of these issues that are part of the core concerns. And of course, we have long had laws that restrict working conditions of children under certain ages, especially in abusive or hazardous occupations. And as I've said, I think we've embraced that convention in any event of the ILO. So we are, in many ways, in sync with what the ILO does. And of course, there's this whole area which I don't get much involved in, which you'll hear about today, about the way in which trade preferences may be affected where the country is engaged in inappropriate actions involving labor. And even beyond what we're going to talk about today, whether you're talking about minimum wage or occupational health and safety, all these things are concepts that are embedded in American law today, Social Security, the list goes on. And of course, our laws are continuously affected by these international standards, whether they are explicitly articulated or not. You know, we live in a legal context in which words like due process of law, equal protection of law, involuntary servitude, or in the context of the Alien Tort Claims Act, assuming Cahill-Bell survives, what are acts that in fact violate the law of nations? What acts involving labor? We need to come to terms with those issues. And then, of course, there are the issues of the extent to which we incorporate these international labor standards in private agreements. There's no good reason why a federal district judge called upon to give meaning to the content of these clauses in contracts that are privately celebrated cannot, out of a decent respect for the opinions of mankind, entertain arguments that would result in the enforcement of international labor standards. Not bound, mind you, understand, just to appreciate the policy and the logic and even the universality of some of these standards. There was some key word, I think, that was used by Judge Robin Layton of the South Australia Supreme Court when speaking of international labor standards. And that statement was that international law is sometimes being used to interpret domestic legislations in cases before them, speaking of judges in Australia, or more usually as a source or inspiration to assist the decision-making process and supportive reasoning. And I think that's really the core of the approach to the federal judges these days, always, of course, with fidelity to the domestic law. And finally, I would point out that in a very important way, federal judges are increasingly being influenced, perhaps a better word is sensitized in non-litigation settings to international standards, including international labor standards. The ILO has been actively sponsoring for a number of years seminars for judges around the world to help them discuss international labor standards, just as it's doing in effect today. Many of us, me included, travel to international seminars. We visit foreign tribunals, including labor courts. We have foreign visitors coming to our courts all the time, including labor court judges and officials from other countries. And we're talking all the time about this is what we do, what do you do? We apply this standard, what is your standard? So this constant networking, these constant exchanges of information and experiences help create an awareness that there are different approaches and solutions to what are common problems, or standards, if you will. So in the specific context, it's going to be eminently reasonable, again, not to say imperative, for us as federal judges to understand where the rest of the world, or at least a good part of it, stands on a given issue. And really, this is the same end game, I think, that you have when you get involved in litigation, direct litigation. We're still talking about the potential applicability of international standards. So rest assured, as I close, in both judicial and in extrajudicial forums, we as federal judges will always be prepared to listen. We will always be ready to be educated, and sometimes we may even be apt to be convinced. Thank you. That's it. Is there a Q&A at this point? All right.
We hope so, if you're up for it.
I'm happy to do it. Anybody have any questions? Yes, sir.
It's an interesting thing. I was at the NLRB about a decade ago, and the board members at that time were loath to try to cite international law. And the main concern was that the Court of Appeals would have a very dim view of it. First, they were a little suspicious of the National Labor Relations Act to begin with. But secondly, that there was a view that these U.S. agencies, like the NLRB, purely derive their mandate from a specific piece of legislation. And so there seem to be three areas where it might be relevant. One is in the fact-finding. The other is whether it's binding, which of course it could be. But the area that you mentioned, I think is the most interesting, is being able to cite the international labor standards in a manner that's persuasive, that amplifies that. So I'm wondering if you could speak to that issue about how that issue could be presented to a Court of Appeals and how it's different for a district court.
I don't think it's different for a district court. I mean, you need to sort of, I think, separate this view that you should not look at foreign law or foreign standards at all. That's really a small segment of the judiciary that talks that way. Anything that sheds light on whatever you have in front of you that gives you some, number one, meaning and content, some inspiration even to try and give content to a somewhat nebulous term, or to fortify a position which you find already expressed in domestic legislation is helpful. Truth is where you find it. I mean, if there's a good concept abroad there, think about this. I mean, Scalia quotes poetry, and Justice Rehnquist had literature. I mean, they can do that. Why? That's not part of domestic law. I mean, really, it's really where you find, particularly even a felicitous phrase, for example, will help you. But just to help fortify an opinion, there's really no basis to exclude that, either at the district court level or the Court of Appeals level. And if they say that, I think they're perhaps being intimidated. Yes, you have to ground I think that the fair statement is you have to ground your argument always in solid, positive law of the United States. You can't just come in the general way and say, embrace this concept. But you can do it, and I don't know. I mean, it's a question, really, I think, of degree. If you come in and you overwhelm somebody with all this foreign law, they may miss your point. But it seems to me, if you've got a good argument that you can fortify by citing a standard that is used around the world, I don't know why not. I mean, I was having a conversation with Ms. Joyce this morning about the amicus briefs in the Supreme Court in the Affordable Care Act case and whether the suggestion of basic health care should be a fundamental human right for workers, among other things. Well, yeah, why not? I don't know. It doesn't degrade the argument. It's simply worth mentioning that that's there. And in some ways, when you think about it, the fundamental right, well, they're arguing now about whether this should be sustained or not. And maybe the concept, you think about it, the idea that this entitlement to basic health care is recognized worldwide, well, maybe it's the kind of thing which the Commerce Clause ought to justify. There's that. Now, I think you have a majority on the court now that's somewhat hostile to that argument, but I would be convinced, I mean, I would be willing to hear that. I'd say, yeah, that's true. That's true. There are some basic standards. I want to know about this. On the other hand, if you said things like everybody's entitled to a minimum wage of $1,000 an hour, which some lawyers in this city charge, I don't think you'd find you wouldn't find a very hospitable reception to that. But yeah, I mean, I think it's legitimate to make it. Always a question of degree. I mean, I think that's it. We really still want to see the hard American law first, informed, inspired, assisted by the citation to the other source. Anyone else? Nancy?
I'd just like to say if people make comments or questions, it would be great if you say who you are, where you're from, because I know who most of you are, but not everyone will. Judge, I just wanted to say that one of the things that you didn't say much about, but I think is so important, we at ILO look at how are human rights being shaped and evolved in the working context, and how is health and safety promoted, all the kinds of issues that workers care about. And what we see a little bit from the understanding that the judges of the world have to take this on as well is how important this idea of judicial diplomacy is, and how important it is for, frankly, judges in other countries to learn more about the U.S. system and vice versa. And because the problems, the globalized problems, just like the globalized economy that we're functioning in, are going in a direction that judges are going to be asked to know so much more and to have a sense of a global context. So I just wanted to invite you to say a little more. I know you've done a lot of work in Brazil. I know you've worked on child abduction. And I just wanted to ask you to say a little more about what you see those challenges are and how those people in this room can help judges knowing that these things are coming.
Well, I think that was really the basis of our initial contact, wasn't it, Nancy? You seemed fascinated by what I was telling you about some of the work that I had done under the Hague Convention on the Civil Aspects of International Child Abduction, which is where a child gets taken abroad by a parent or a relative and basically detained against the wishes of the other parent. And we actually have a formal network that the Hague Convention has set up of judges around the world. And I was designated by the State Department to be the federal judge. There are 3 state judges who are part of this network, and we talk regularly. We go to meetings regularly with our colleagues, and we talk about common problems in the context of specific cases. And it isn't that we are in touch to say this is the way you should decide the case, but we are often in touch with our counterparts to say this is how the American system works, or to find this is how the Dutch system works. And then that person often can be in touch with the local judge handling the problem, and the logistics of the solution can be worked out. And that concept really does have potential applicability. I would say it's a fair statement that judges nowadays do a lot of international contact. They have a lot of international contact in terms of meetings, receiving people all the time. I use the term judicial diplomacy. It's not a real term. I made it up. But the fact is there are a number of federal and state judges who are always receiving people from abroad, including labor judges and others. And as I say, although it's not a formal network the way it is under the Hague Convention, there's some potential there. In fact, there's a potential for even more contact. I would say the idea of inviting judges, for example, to more of your international programs. Nancy, you answer this for me. Has there ever been a program in the United States for American judges about international labor standards?
No, we're hoping that.
Well, that's what. That's a recommendation, because that right off the bat, I mean, I know I've seen you've done it in Europe and Africa and other places like that, but you haven't done it in the United States. And as long as it's not to some cushy resort, as long as it's not to a hardship place either, but Washington's a good middle ground. If you were to have something like that, though, there wouldn't be inappropriate. And this is where it's easier if you're an arm of the United Nations and not allied to the Second International or something like that. Better to deal with you on that grounds. But that's another way to go at it, to have judges talking about it all the time. The practical application, because they really bring to the table much what I bring. You know, interested, know a little bit about it, like to know more, and this is a way to tell them more about how these standards work. And I suppose you could do at law schools, you could do moot court type programs, education in the schools about how labor standards apply. It's a fascinating issues. Get a Supreme Court justice to come and talk to you about it. They got Justice O'Connor, they got Justice Breyer. Try if you can see if you can get Scalia and Alito and some of those others to come around and talk about it. But those are all ways. We are in the middle of an educative process, really. We are becoming more and more global. I think the federal judges are reaching out more. We are receiving more people from abroad, and there will be greater sensitivity over time, and I think you could do things to impel those meetings. Anything else?
Michael Gadbois, Georgetown Law School. I wonder if you would talk about labor rights and contrast how you would approach them as a human rights issue versus as an economic rights issue, and whether that distinction bears any relevance. You mentioned labor rights linkages to trade. So that has become an increasingly important piece of how labor rights are advanced. And related to that, the recent financial crisis being global in character and breaking down some of the balkanization in our views of how financial law versus trade law versus labor law. Do you see that crisis spawning kind of new laws and new institutions, new ways of looking at old problems?
Well, it's a good question. I would say that your best bet always here is to try and deal with contracts and international, even bilateral or trilateral or whatever the agreements are, contracts between parties, whether you're talking about trade preferences or you're talking about direct dealings for people who are have contracts with the United States, or even private, between and among private parties, union contracts with foreign companies. Applying a contract is really not a problem for a judge. You don't really need to worry too much about whether it's human rights or whether it's economic or financial. I mean, the idea, what does this term mean? What does it mean if you're talking about, and usually I think you're a little more explicit than saying a decent wage. I mean, you probably, and I'm not familiar with how all these contracts work, but enforcing specific contract language is an easy walk for a judge, in the sense of not having to deal with all these constraints that I talked about. Hard to talk about a judge enforcing economic or financial rights independently of human rights. Again, even the human rights issue has to be tied to legislation. And if we're talking about the Alien Tort Claims Act, that right now is really, it's at risk, frankly, under the Kiobel case. I'm not quite sure where we're going with that. We may find ourselves in a situation where this court says we're just not amenable to this at all. But as I say, I think mostly relying on specific agreements with, whether it's things that unions negotiate with employers or however that gets done, or the United States government establishes with trading partners, that's the kind of thing where you're going to get a much easier hearing, a much more receptive hearing in the federal courts. Some of these large ideas, like, as I say, human rights violations, you sort of step back and say, whoa, that's not, I don't do that every day. That's for somebody else to deal with. We are always willing to listen. I think there's that. Don't don't expect necessarily that some of these arguments will be embraced. Many judges will say, I need to put this aside. I need to deal with the hard case before me. Not sure that helps in the answer, but that's where I am. Yes, sir.
John Higgins, I'm here on the faculty of the law school. Is a judge less likely or less amenable to looking at international standards if it's a criminal case before him than if it's a civil case? Witness, for example, that case you referred to a moment ago that you had where the person's serving 7 years. Would you be interested in international standards in criminal proceeding as distinguished from, let's say, a lawsuit by that woman suing her employer for keeping her in that basement?
Well, that may yet come. I haven't gotten that suit yet. That may be out there. But yeah, I mean, I can see in the criminal context, didn't have it happen in that case, but there is an issue of just how can you fairly treat somebody. And then look at that case. This young woman who was about 15 at the time, came from a tribe in Nigeria, and things were not great where she was from. She probably lived a better life in the United States than she ever was living in Nigeria, but not nearly the kind of thing that we would expect to be here. And I suppose it might work in reverse if somebody would say to me, well, you know, the standard in Nigeria is down here, and basically there was some argument to that effect in this case. And the answer was, well, too bad, we're not there, we're here, and you have to comply with this higher standard. So yes, I mean, I can see how, at least even in reverse, an international standard might be relevant in the forced labor case. That you would say, well, everybody, you can't, that in effect it rebuts the argument that, well, everybody works this way in Nigeria. And the answer is no, they really don't, or they shouldn't, because the rest of the world doesn't say that. They don't agree with that. I could be persuaded by that. I think that's interesting possible approach.
Stefan Markowitz with Lippert Mendelsohn. Judge, thank you for your presentation. I'm very interested in what you have to say. I want to talk a little bit about the most recent UN Guiding Principles on Business and Human Rights, where one of the pillars is that a business or a corporation established a human rights statement. And many companies, through sort of corporate social responsibility initiatives and things of that nature, are putting in and promulgating independent, sort of individual, unilateral statements, many of which, in fact, expressly reference international labor standards and not sort of using that broad term, and we'll talk a little bit about that in a later panel, but speaking to specific conventions. And I'm just curious, you've spoken about the contract concept of how a U.S. district judge could interpret and then how they would fit into how international labor standards could come into an actual hard case as a matter of hard law. But how do you see it fitting in with respect to sort of these unilateral statements, company policies, company declarations, things of that nature? And what are the risks? What is a company to do in these kinds of scenarios in terms of how do they bring this stuff into their...
Well, that's a very good question, and we see the analog of that domestically all the time when someone says, well, I read the employee manual when I came to work here, and it said this, that, the other, and I'm not getting that. And therefore, you reached your, agreement with me. And so our challenge is there an agreement here? I mean, what do we have? Is it really an enforceable contract? Now, in some ways, of course, it's always available to rebut the argument, like when the employer says, we didn't have anything like that in mind, because the answer is, well, yes, you did. You said this. On the other hand, do you have an enforceable agreement? Going back to Judge Barquette's language, tough to deal with this. Do you have an enforceable contract there? And I suppose the tighter the language, the narrower, if you will, commitment on the part of the employer, the more likely that you might be able to infer something. Particularly, like any contract, if you've got a statement here which suggests an agreement. Not every contract has to be in writing, as we all know. So there might be some practice that, in fact, has gone forward under the general declaration which demonstrates that there's been an understanding, a custom and practice, or whatever you're talking about, that might give content to the oral agreement that would exist between the parties. I mean, I don't want to dissuade companies from making these generous statements along the way, but the short answer, I think, is yes, quite possibly. Depending on circumstances, you could have language that would be if not directly enforceable, available to rebut a suggestion that we never intended that. And I don't know how specific your contracts get when you get out in the field and say we're going to abide by these standards. That's a pretty strong statement, that we are going to abide by the international labor standards. I'll have to see that in context, but right now it feels like you're on your way to a contract. I don't want to dissuade your clients, Mr. Markowitz, from putting that in their contracts, but yeah, quite possibly. And that's going to really be left to the creativity of the lawyers, of the people who are going to bring the suits. Just what can you put into a case to make it plausible? Anything else?
So let me just say that, at least for some of today, Judge Musetti is going to continue to stay with us.
Yes.
And he also has been asked by us, the organizers, to offer comments as from the judicial perspective when he sees fit in the panels, if he wants to.
Happy to.
Because what we want to keep in mind what we're thinking about here, not just the standards, but how judges are being asked to think about them also. And, but also I'm hoping that means that you would be available to have further conversation with people.
I'll be pleased to, sure.
And if I might just say, we promised a coffee break. I think we do need a quick coffee break. And so, Your Honor, if we might close this for now.
Stand adjourned then.
Everyone can be back in their seats by 25 hours.
It was mostly a matter of saying why I'm not an expert. I'm glad. As I say, we're ready to be educated. Take nothing for granted.
I know every judge is not as open-minded as you are, but it's just see in a very natural way what kind of things you're doing. I mean, it's hard to put yourself in somebody's shoes.
You really have to go back to basics. I think that you folks do carry a lot around in your head, and we don't. We don't really know all of the background. As I said, I suspect that something that will not know exactly what the ILO is. Tell us that you're legit.
In my speeches, I said, no, we're not the staff union of the UN. That's the first one they tell me.
And we're not the Wobblers.
No, we're not the ones.
Well, very pleased to be part of it. Yeah. Thank you so much. I'll have, do you take this? I can send you a copy of my remarks after. So some of it was a lot of it was ad-lib, but I could put in some other things.
I think you have the option. I don't know what else.
I've got legislation,
Toby, did I guess you were?
Yes, sir. Yes, you did guess correctly. I was impressed. I walked in with, that's not very much.
No, I just want people, yeah, where people put their stuff on it. No, I think useful.
And I didn't know what the commission, I didn't know that last promotion.
You know, I don't know where is she? I don't know if she is.
She's in Valley at the moment, but she's in that path.
Oh, that's right, I did know that. Yep, I did know that, yeah. Yes. Yep, she worked.
John Haines.
Before.
Sorry, name
No, I guess there was only that.
But no, it was really just great to see. You know, now she's sitting on the beach.
Life's tough.
Very good.
Let's see, Molly? Mukor Romasillo.
I saw, I'm sure he's right up there. Very good.
City.
So the LL for this is coordinate your lesson learning.
Yes.
If you can coordinate your panel,
Who's an L?
always remember to coordinate.
I don't think so, you know, or, yeah, maybe they are. No, you're right, mic off, mic on, you're right.
Oh, well.
Do you want to do, does it matter? I was just
So-
like, oh, God, this is such a high.
You heard what you were saying, right? That field hour.
If we talk from here or talk from there, does anybody?
Well, I mean, she's, I'm going to do my panel, I'm going to stand up. Now, whether the panelists want to sit down or not.
Okay.
I noticed yesterday on the program at Georgetown, on the alien towards plane.
Oh,
One moderator stood up, the next moderator sat down. So I-
Because after we,
And then some of the people stood up. So
Nancy was the
I'd much prefer to stand up.
I do too. I have to tell you with this little, and it's, because I'm referencing
the judge said
was proposed on Tuesday. I have notes, so I'd rather be a closer, it doesn't like bugs.
Warm it up to you. I'm not very silver, so
Are we, standing to present? So we can let. Okay, we are. Yeah, sorry, we are. There we go. Okay, there we go. Thank you. I'm a chapter. This is, I feel like a little child sitting at the
Yeah.
table.
Well, I always like to stand because I'm so.
You should sit down for a second at this table and see how high it is.
No, it's terrible. I already did.
Do you feel like a little child at the adult table? Hello.
I don't want to be.
Judge Motz in Baltimore,
Yes.
federal court of Jersey City, told us, of course, nobody in the courtroom except the lawyers. And he said, don't understand, just talk to me. And I said, no, I can't, I'm sorry, I can't do it. Can't do it, it's too many years of training.
Hey, John?
One thing we have to do is that the Catholic University has a small thank you that they'd like to present to you among the speakers. And so John Higgins is representing Catholic
On
University.
behalf of the school, thank you so much for coming to a wonderful presentation.
Let a couple of, good morning, everybody. I'm Karen Tremontano, and I'm president of the Global Fairness Initiative, and I'm honored to be here. Microphone is, it's for recording only, okay. Thank you. Okay. So I guess I have to, these lights are very hot, plus post. Post-50 is setting in. Turning up the year would be good. Okay. All right. Good morning, everybody. I'm Karen Tramontano, president of the Global Fairness Initiative, and I'm honored to be here. Our first panel is going to be addressing international labor standards and labor exploitation in the global supply chain. And it is just an outstanding panel. You have the bio, so I'm not going to go through everyone's background, but they are all experts, and we're just honored that they could join us this morning. I want to start off with just a few remarks, hopefully to maybe set the stage a little bit. The judge referred to a number of issues that our panel's going to address, one of which is about the social clause debate. This debate primarily framed in how do we embed core labor standards into a framework of international trade has been going on probably since the creation of the ILO. It regained urgency in the first WTO ministerial in 1996, and the new wave of trade agreements, beginning with NAFTA and then continuing on with U.S. bilateral agreements with Colombia, Peru, Panama, and South Korea. And probably one of the biggest failures of my career was being the Sherpa to the WTO ministerial, affectionately known as the Battle in Seattle. I try not to admit that very often. But in this world defined by globalization and accelerating international trade flows, the challenges to labor rights posed by sprawling, complex, and often murky networks of supply chain are more relevant today than ever before. The increasing outsourcing of production, workers in local environments marked by corruption or institutional inability to enforce labor standards means that forced and child labor are persistent problems. In the United States, legislatures, judiciaries, and civil society have been grappling with where and how these considerations should fit within our domestic legal context. The elimination of forced labor and related evil of child labor is at the center of the ILO's work, as we all know, forming as it does two of the four fundamental principles of international labor rights. In addition to the Declaration of Principles, 4 ILO conventions address the range of concrete practices encompassed by those terms. And each of our speakers will be talking about those core conventions. But accountability and enforcement are another matter, however. A country may have ratified the relevant conventions and passed legislation to execute them while lacking the will or ability for enforcement. The prevalence of informal economies, which connect to legitimate supply chains through corruption or willful ignorance, keeps child labor or debt bondage under the radar. The rise of human trafficking spurred by vulnerable migrants seeking to sidestep host countries' immigration laws makes it all too easy for traffickers to intimidate and manipulate workers through confiscation of identity documents or outright kidnapping. What then are the options when considering a globalized economy dominated by multinational companies like Nike or Apple, which has been recently in the news, which are ostensibly American but whose supply chains snake across the world? One approach is based in civil society, in which organizations like the Global Fairness Initiative, which I founded about 10 years ago, engage the private sector, informal workers, and most importantly, the government sector, to develop effective approaches to move informal workers who are among the most vulnerable into the formal economy. or organizations like the Fair Labor Association, which partner voluntarily with the private sector to introduce systems of accountability along supply chains. Accountability that includes internal monitoring systems, required public reporting, independent external monitors, unannounced audits, third-party complaint systems. All of these mechanisms are, in a sense, voluntary mimics of the legal framework that should be enforcing core labor standards. Another approach is to embed those labor standards into free trade agreements and, in effect, make trade liberalization contingent on stronger labor laws in developing countries. This approach, however, is attacked from a multitude of angles, from developing countries who argue that it amounts to veiled protectionism, and from labor law proponents who critique the clauses are unenforceable and therefore ineffective. Finally, there is the domestic U.S. judiciary and the legislative system. While the United States has ratified both the Abolition of Forced Labor Convention and the worst forms of child labor, U.S. courts have not always applied them, as we heard this morning. So the U.S. Congress in 2000 has passed the Victims of Trafficking and Violence Protection Act, which grants protection and temporary visas to victims of human trafficking. And in 2010, the California passed the Transparency in Supply Chain Act, which requires all companies worth over $100 million that do business in the state to regularly disclose their efforts to monitor and address labor abuses. But again, the issues are one of enforcement. These efforts are far from complete or satisfactory, so the question remains, where and how should the judiciary engage with and address these issues of forced labor, child labor, supply chain issues in the context of international supply chains? That's what I hope our panelists are going to discuss with you. We're going to leave room for questions, so each of the panelists will have some time to present, and then they'll come back and perhaps comment on some of their colleagues' remarks, and then we'll open it up to questions. So thank you again, and with that, I'm going to turn it over to Stephen Schneebaum, who will begin with the Alien Torts Act.
Good morning, everyone. Judge Musetti is going to be a tough act for me to follow, I'm afraid. So what I propose to do is to attempt some groundwork laying for the rest of this conference by suggesting that before it can reasonably be discussed, the question of the incorporation of international labor standards into U.S. law, we need to know a little more about what we mean by the incorporation of any international law into the laws of this country, and that in turn requires a little bit of exploration of what international law is. Now, in my presentation, I'm going to, I'm afraid, demonstrate the sort of lack of tact of a practitioner rather than the diffidence of a federal judge. But I hope to cover some of the same ground that the judge just did, but from a slightly perhaps different perspective. First of all, I want to, in discussing the incorporation of international law, I want to start from a very clear distinction. I'm going to be talking about international law, not foreign law, not the laws of other countries, but international law as that term is generally recognized. And if we look to, for example, the statute of the International Court of Justice for guidance on the definition of that term, we see that the court has, since time immemorial, I mean, going back to its predecessor, and therefore going back to the Treaty of Versailles, defined international law as coming from four sources. Most of you know this already: treaties, custom, general principles, and then as a subsidiary source, the writings of scholars and judges who write professedly about the law. So given that the sources of international law then are treaties and custom, the question arises, before this international material can come into a U.S. courtroom, how does it walk in? What door does it come through in order to be proper material to cite before Judge Musetti or his colleagues, or to cite before the courts of appeals or before the Supreme Court of the United States? Well, Article 6 of the Constitution provides, of course, that treaties are part of the supreme law of the land. But when the Constitution uses the word treaties, it uses it in a very specific way from a domestic perspective that is not the same as the way in which that term is understood from an international law point of view. From an international law point of view, a treaty is a compact between states, two or more states agreeing to do or not to do something. But from the U.S. constitutional perspective, according to Article 2, Section 2, a treaty is something that has been signed by the President and ratified with the advice and consent of the Senate. That is the kind of treaty, and only that is the kind of treaty that constitutes the supreme law of the land. All other treaties, all other international agreements, whatever their titles may be, must be incorporated into U.S. law through some legislative vehicle. They have to be enacted in some way. Some of them have been, some of them have not been. And of course, additionally confusing the situation is the question of the judicial creation of the notion of self-executing treaties. Some treaties are self-executing, meaning that the simple fact of their having been adopted as the law of the land means that they can be relied upon as the source of rights that can be enforced in U.S. courtrooms. Other treaties that have been adopted under Article 2 are not self-executing, and still others are not treaties at all. The World Trade Organization agreements, for example, while they're treaties in an international sense, are not treaties in the special sense of Article 6 of the Constitution. So the incorporation of treaties into U.S. law is reasonably straightforward, but unfortunately, the Constitution gives us no guidance at all about the incorporation of international custom. We have some evidence of what the Founding Fathers may have thought. We certainly have Thomas Jefferson's famous line about paying a decent respect to the opinions of mankind, but we don't know much about what the founders had in mind in terms of the incorporation of customary law. Customary law, of course, means, according again to the International Court of Justice, the intersection of state practice, not necessarily universal, but broad-based state practice, together with what the court calls opinio juris, the sense that a practice is followed out of a sense of legal obligation, not just by coincidence, not just out of comity or out of deference, but out of some sense of legal necessity. So that kind of customary law, which, again, the Founding Fathers may have thought was very important, is not so much as mentioned in the Constitution. So how does it get incorporated? Well, it gets incorporated in a number of ways. First, it is open to the Congress to make specific reference to customary international law in legislation, and it has done that on a number of occasions going back to the early 19th century. So, for example, when the Congress enacted early legislation prohibiting piracy, it didn't attempt a new definition of the term piracy. It simply said piracy as that term is understood in the law of nations. There was no treaty governing piracy, and so that meant that Congress was expressly incorporating customary international law into legislation. The fact that gave rise to the famous Paquete Habana decision to which Judge Massetti referred this morning, the decision of the Supreme Court in 1900 in which Mr. Justice Gray said that international law is part of our law, the basis for that case, the underlying facts were that President McKinley, in his declaration following the declaration of war against Spain, President McKinley said that the law of prize, the law of permitting the taking of enemy vessels, would be governed by the law of nations. And the question was, what does that mean? And the Supreme Court of the United States had no trouble interpreting that and finding that definition to be binding because it had been incorporated into the executive proclamation. Now, when the courts interpret international law, and especially customary law, they walk into a thicket. They walk into difficulties of all sorts, political, exegetical, linguistic, all kinds of difficulties. And sometimes there has been, especially over the last decade or so, there's been a bit of a pushback from those who believe that international law has nothing to do with the law of the United States or should have nothing to do with it. Judges who apply international law in American courtrooms have been accused, for example, of imperialism, that is, arrogantly asserting the rights of the United States to control what people do overseas. International law is sometimes accused of indeterminacy. We don't know what it is, no less than Chief Justice Roberts, in his confirmation hearing, said that one of the problems about applying international law, he said, is it's like looking at a photograph of a crowd. You can always find a friend of yours in there somewhere. You can always find someone, something, to support whatever proposition you're going to be arguing. International law is sometimes accused, or at least judges who apply it are sometimes accused of inefficiency. What in the world is an American judge doing in Washington, D.C., hearing a case in which I represented the plaintiffs, alleging that East Timorese peasants had been burned out of their homes in violation of international law by an Indonesian military force retreating from what we now call Timor-Leste? What is this case doing here? And that notion that somehow there's something offensive about American courts asserting jurisdiction over cases that arose out of facts occurring overseas is a problem difficult to shake. And as Judge Massetti indicated this morning, Justice Alito specifically raised that question during the oral argument in Kyobel. That pushback, all I think, is based on the notion that there is something fundamentally different about international law as compared with domestic law, and the fundamental difference is this. It doesn't have democratic roots. It doesn't come from a democratic source. We know where our legislation comes from. It comes from the two houses of Congress voting and the president signing, or the president not signing and a veto override happening. But we don't know where international laws come from. We don't know where these customs, to what these customs owe their origins, and who it is who's behind them. And so when we cite international law sources in U.S. courts, we need to be prepared to deal with each of those objections. And I think each of them can be dealt with, and perhaps in the Q&A session later we can talk about that. Now let me just say a few words about the Alien Tort Statute. The Alien Tort Statute is, in my submission, simply an example of the points that I've been trying to make this morning. It happens to be a statute in which Congress made express reference to the law of nations. And since it didn't say, it said the law of nations or a treaty of the United States, so quite obviously what it intended by the term the law of nations was customary law, not treaty law, because that was already covered. So when the Congress said that the district court shall have jurisdiction over tort suits brought by aliens alleging violations of customary international law, what did they have in mind? Well, in 1980, of course, in the famous Filartiga case, the Second Circuit Court of Appeals said that one thing whether they had it in mind or not, but one thing they opened the door to was litigation alleging violations of well-established principles of international human rights. And that Filartiga served as a precedent for lots of human rights litigation that went on until 2004, when for the first time the Supreme Court had to address a statute that by that time was 215 years old and had never been mentioned in a Supreme Court decision before. And in Sosa v. Alvarez Machain, the Supreme Court said that the statute says what it means and means what it says. If a violation that gives rise to a suit under the Alien Tort Statute is of a norm that is specific, universal, and obligatory, then that is an adequate basis for jurisdiction, federal jurisdiction, and that is the answer to the question, what is this case doing here? Well, that's all well and good. That was 2004. Here we are in 2012, and the case to which Judge Massetti referred this morning, Kyobel against Royal Dutch Petroleum, raised the question whether corporations can be defendants in Alien Tort Statute cases. Interesting issue. Many of us have thought and written a lot about that issue. Many have opined, many courts have opined, that there is no particular reason why corporations can be exempt from the sorts of claims that might be brought against their officers or against their individual servants. Nevertheless, after that argument was heard in the Supreme Court, just a week later, the Supreme Court asked for re-argument, not on the question of corporate liability, but on the question whether the federal courts can ever have jurisdiction over cases that arose overseas and presumably between foreigners. That question raises very sharply, into very sharp relief, the bigger question of what is to be the role of international law in the law of the United States. And I will for now conclude with the thought that it is hard not to be pessimistic about what the Supreme Court is likely to do with this case. And there is quite apparently, there is a ready constitutional means of addressing. Of course, the Supreme Court always abides by the principle of never making a constitutional decision if it can avoid it. But bear in mind that cases under the ATS always have alien plaintiffs. They have to. That's a prerequisite. They virtually always have alien defendants, especially if American corporations can't be sued, see Kyobel. So if they have alien plaintiffs and alien defendants, they can't arise under diversity jurisdiction. And the Supreme Court said in Sosa that the ATS is not a substantive statute, it's a jurisdictional one. So there's no basis for claiming that ATS cases arise under federal law. So if the Supreme Court goes that route, how do we answer that question? What is this case doing here? Thanks.
Thank you very much, Stephen. I think you will have a lot of questions. What is this case doing here is also an article that Stephen has recently published, which I commend to you. Earl Brown?
Thank you. I think the judge and Karen and Steve have set the context. I just want to give a different practitioner's perspective here. I was a labor lawyer in the state of Alabama, and my first case was representing black sharecroppers in a very famous county in a peonage case. And I had sued in an Alabama court, and I asked, I was brave enough to cite some international law, and the judge asked me, "What's wrong? Isn't Alabama law good enough for you?" I could do his accent, but I'm not going to do it. And I think that raises the fundamental question that Steve addressed is, what is this alien law? I think I agree with the judge that the debate about whether you can cite foreign law is a very subsidiary issue. I think it's amply answered by Breyer. I can read what I want. And the fundamental question is that judges are, particularly federal judges, but all state judges. And in my current experience for the Solidarity Center, Thai judges, Chinese judges, Sri Lankan judges, all of whom I've appeared for directly or indirectly, are wanting to know what is this external source of authority and what is my authority to use it. So I think what we end up with, given that fundamental orientation of all judges that I've ever encountered, is that the law is developed in what Breyer called a messy conversation. And I would like to expand Breyer's outside courtrooms, outside legislatures. I'd like to expand Breyer's notion to throw in some more stakeholders. Breyer said there's a messy conversation with law schools, lawyers, and other elites. I would like to expand that to include trade unions, factory managers, all people working in the global economy who have practical problems. And one thing is very clear, that law arises out of solutions to these practical problems. For example, the Uniform Commercial Code that we occasionally encounter in our own law comes out of the practical problems addressed by the Amsterdam traders about the trading in goods from 1500 on. All of law comes from practical problems, and corporations, globalized corporations, are facing a dilemma. It's all well and good to maximize profit, even if you have to cheat, even if you have to squeeze labor. And it's all well and good to find these spaces in the world where standards and law are not enforced, and to press. But it's plainly agreed by many people that think about it that you can't run a global company that has to answer to trade unions in Brussels, to consumers in Ann Arbor, Michigan, and to Brazilian dock workers successfully by ignoring fundamental labor standards. It's not sustainable as a global corporate enterprise. And out of that fact alone, out of that necessity, you will see international labor standards creep back in to American law. Because international law is not foreign anymore and never really was to domestic law. For example, our Title VII law, when we first faced the question of desegregating the American workforce, has crept into CEDAW, it's crept into the Conventions on Race Discrimination, and to the ILO standards. It's informed those. It's informed Chinese law. On the other hand, international standards are increasingly informing our law through trafficking acts, through the Alien Tort Claims Act, although that's, I think, a very boutique area of law at this point. Reading the order on re-argument, I think now we'll have human rights enforced on the high seas only. If you're a seaman on a vessel outside any sovereignty, you might have a claim. How you'll get to a federal court to raise it in time is, I don't know. But I think also international law arises out of the judges are creatures of the sovereign state. And they want to say, who told me I could do this? And we presented an international law argument to a Thai judge based on a treaty Thailand had signed with Burma and the ILO. In 1929, the Thai government had completely forgot it. It was quite surprised that it had signed it. And it said you have to treat Thai migrant workers and workers' compensation matters equally. Burmese migrant workers were injured in Thailand equally with Thai workers. This was a shock to the Thai Foreign Ministry. They did find the original signature copy and was a great surprise to the Thai labor judge. And he says, what is this? So we presented him with an ILO comment saying Thailand needs to enforce this, and he looked at it, and there was an immediate hubbub and flurry and several weeks of consultations, and he issued an order in conformity with the ILO decision. But he was so nervous about this. I think that he was reacting like the judge we heard this morning from Greenbelt, the federal judge. Who gave me this authority? That's why I think judges are the last stop for international law, not the first. And I think that today's practical imperative for international law comes not out of sovereignties and sovereigns acknowledging, oh, this law should now be incorporated because I have this paragraph in my own law, but because of the failure of sovereignty. The failure of sovereignty to deal with the severe oppression of Burmese migrant workers in Southeast Asia, amounting to slavery. The failure of the U.S. courts and political system thus far to address an appalling resurrection of racist Jim Crow in the state of Alabama, not to act more promptly, is a failure of sovereignty. And out of that, people, companies that have to practice in Alabama, the Japanese manufacturer of cars that is arrested as he comes home from a dinner because he's not carrying his Japanese passport in the state of Alabama, is going to raise and has raised international law questions. The challenge to that racist Jim Crow law, which would make every single transaction between a migrant worker and any other person suspect, going straight back to Jim Crow law, has been challenged by SEIU and many other people on international law grounds. The invocation and imperative for international law comes out of the failure of sovereignty. Migrant workers who migrate in the world and have not even a phone call to make to anybody to say this is wrong. Several people in this room represent such workers, locked in these migratory prisons literal prisons or figurative prisons. There is no law at all, and the only place they can go to, confronted with Jordanian authorities who do not enforce law and everybody else who doesn't enforce law, is international law. I think that also the failure of sovereignty gives force to the Ruggie principles, that more and more the treaty laws will bind private parties, private armies, private corporations, because of the need to have sustainable employment practices and trading practices and environmental practices globally. The last to know will be the federal judiciary at the highest level. Earlier in the system, I think the federal judges will confront more and more transactions, commercial transactions, maritime transactions, claims of migrant workers in the U.S., persons in the U.S., covered by our Constitution, that incorporate international law principles, codes of conduct that become more and more binding because they expressly incorporate by reference certain principles. So I think all of this conversation is going to move from the HR departments in companies to the legal departments in companies and to lawyers, including young Chinese lawyers who have gone and listened to things like this in China and other places, who say, did we do our due diligence? Who are these armed guards you have protecting this mine in Indonesia? And so that's how I think, out of the needs of a global economy and its stakeholders, we get international law, and it will migrate back in the daily work of federal judges and state judges, and they'll be very nervous about it, but they'll have to deal with it. Thank you.
So we're going from the failure of the judiciary to the failure of sovereignty. That's a blanket statement. And Shelby's going to tell us, I don't know, I don't think you're going to lift us up, Shelby, because I think you're going to tell us about some of the real crises that are out there, but hopefully present some solutions. Thank you.
So I'm going to take us through a human trafficking lens and look at it through that angle. And also try to take us down the road of governments, but also private actors, so companies, corporations, and then also consumers or civil society, and how that might be guiding this type of implementation or even creation of law. So trafficking is defined in the United States through the Trafficking Victims Protection Act of 2000, including the reauthorizations of 2003, 2005, 2008, not yet for 2010, we're still waiting on that, and the Trafficking in Persons Report. The Trafficking in Persons Report comes out of the Office to Combat Human Trafficking in the Department of State that looks at 184 countries, including the United States. And that's based on the Trafficking Victims Protection Act, but also the UN Protocol to prevent, suppress, and punish trafficking in persons, especially women and children, called the Palermo Protocol. And the TIP report looks at issues for each of these countries, again, including the U.S., on forced labor, sex trafficking, bonded labor, debt bondage, involuntary domestic servitude, forced child labor, child soldiers, and child sex trafficking. Now, the finding of Congress when it issued the first Trafficking Victims Protection Act was that the international community agree that trafficking in persons involves grave violations of human rights and is a matter of pressing international concern. That the international community has repeatedly condemned slavery, involuntary servitude, violence against women, and other elements of trafficking through declarations, through treaties, through UN resolutions, reports, including the 1957 Abolition of Forced Labor Convention. So it's, in a sense, we are incorporating international law. We've taken it to make domestic, but certainly very influenced by international law. And as Lou DeBaca, the ambassador at large for the Office to Monitor and Combat Human Trafficking, that is overall in charge of that TIP report, said on Tuesday as he testified before the House Representatives Committee on Oversight and Government Reform. He said the Trafficking Victims Protection Act of 2000 continues to serve as the touchstone for our efforts to combat this crime, both at home and around the world. And they know that this global market that exists for cheap goods and for commercial sex fuels the demand that traffickers exploit. Secretary Clinton, earlier this month, when she chaired the President's Human Trafficking Task Force, stated that this information becomes incredibly important when you think of the buying power of governments. Looking at that massive roster of government suppliers and government contractors. And governments lose credibility, including the U.S. government, when its own policies, procurement, and personnel practices are making the problems worse. So now kind of going down the road of looking at U.S. contractors. I don't know if you know this or not, but there is a zero tolerance policy for human trafficking for U.S. contractors. And what that means is that U.S. contractors and their employees are forbidden to engage in severe forms of trafficking. That includes, as it's defined under the TVPA, sex trafficking in which a commercial sex act is induced by force, fraud, or coercion, or in which the person induced to perform such an act is under 18 years of age. It also includes the recruitment, harboring, transportation, provision, or obtaining of a person for labor through the use of force, fraud, or coercion for the purpose of subjection into involuntary servitude, peonage, debt bondage, or slavery. That's under the FAR 22-1702. But it also includes that federal contractors are forbidden to procure commercial sex acts or use forced labor in the performance of a contract. This requirement applies to all contracts, all contractors, and subcontractors, including those for commercial items. Government contracts, it's further stated, shall require contractors and subcontractors to notify their employees of this zero tolerance policy. Also, what activities are prohibited, and also the actions that can be taken against them if they violate those activities. But anti-trafficking compliance is about more than just regulations. With the amendment of the 2005 Trafficking Victims Reauthorization Act, the U.S. government has extraterritorial jurisdiction under U.S.C. 3271 for prosecution of human trafficking by federal contractors, their employers, or their employees, and subcontractors at any tier. That's any U.S. contractor, not just DOD. Universities are included that. If you are a U.S. contractor, you fall under that provision. But how are we aware of when violations take place? How is that being enforced? And responding to increased media and congressional interest about the fact that that might not be enforced at the moment, or at least not being effectively enforced, a new law was passed in November 2011. And that requires surveillance of contractor compliance with human trafficking rules. Contract administrators must maintain surveillance over contracting compliance with trafficking in persons, and this was specifically for DOD contracts for services, incorporating the FAR that we talked about, combating human trafficking in persons. Now, on Tuesday of this week, groundbreaking for this Congress especially, move was that there was bipartisan companion bills introduced in the House and the Senate to end trafficking in Government Contracting Act. And that's based on the fact of the findings that there are more than 70,000 third country nationals recruited from countries like Bangladesh, Fiji, the Philippines, that work for contractors and subcontractors of the U.S. military in just Iraq and Afghanistan. The Defense Department, State Department, USAID also rely heavily on third-party nationals worldwide. And when these employees are lured by the promise of lucrative jobs, they often find themselves the unwitting victims of illegal and fraudulent employment practices. Their passports may be confiscated. They find themselves in indentured servitude with minimal wages, heavy debts owed to labor brokers, and also many suffer harassment and repeated sexual abuse. So this legislation that is being introduced takes a measured approach to improve both the prevention and the detection of this really exploitative and coercive labor practices. It requires contractors with contracts over $1 million to implement compliance plans to prevent trafficking, to stop this confiscation of passports, stop holding their passports, stop misrepresenting wages, misrepresenting the location of employment. Stop using labor brokers who are charging exorbitant recruiting fees and activities that support this procurement of commercial sex activities. For accountability, these contractors are required to notify the Inspector General if he or she receives credible evidence that something is going on either within the contractor or within a subcontractor relationship. And enforcement, it expands the criminal prohibitions that prevent fraudulent labor practices, especially those ones that are associated with human trafficking and third country nationals. That it's proposed that it be codified, and this range of remedial actions for violations of human trafficking be part of our system and holding our contractors accountable. So while there's regulations that require that already, the thought process here is it's not happening. I think many of us are aware of what we saw with DynCorp, some of the issues that were happening in the field, especially involving commercial sexual activity, looking at sex slavery, looking at labor standards. So the idea here is Congress is responding, as I said, to media and to activists that are saying this is not okay. Further, expanding federal criminal jurisdiction over federal contractors and employees outside of the U.S. I'm sorry, this is not DOD. Okay, so we're expanding again, saying, all right, we're going to look at federal contractors. And the Civilian Extraterritorial Act was introduced by Senator Leahy. And that would grant jurisdiction to impose penalties over federal contractors and employees who commit crimes other than trafficking. So expanding this reach wider to include, for U.S. Contractors outside the U.S., any relationship with U.S. outside of DOD. So again, we're expanding this. And that would include areas of arson, bribery, use of firearms in violent or drug trafficking crimes, genocide, murder, kidnapping, money laundering, sexual abuse, and important controlled substances. The thought is, in this Congress, things are difficult. But the things that might line up for this particular act is, one, it was introduced by the chair of the Senate Judiciary Committee. That's where the bill was referred. And also that 4 of the co-sponsors are members of the committee where it was referred. It's very good thought. This will actually make its way out to the full Senate for vote. It's also supported by the Department of Defense and the Department of State Inspector General to get much stronger issues in place. Another one called the Business Transparency on Trafficking and Slavery Act. That's based on the California supply chain law. And the idea is to have a federal law in place that would level the playing field so that each state doesn't have its own law, but we have one law that reaches across for corporations in the U.S. government. And that calls for any publicly or privately entity that's over $100 million that has to submit a report to the Securities Exchange Commission, and that they must disclose the policies that they have in place to address forced labor, slavery, human trafficking, and the worst forms of child labor. And that those policies must be posted and made publicly available so people can see them and they can react to them. Moving on to, quickly, I know my time is probably running out, but I'll do this quickly. Again, it was already brought up, and I think it's very important, of how international standards are finding their way into bilateral treaties. And we're looking at core labor standards are often being included in those types of treaties for trade. We're also looking at what are individual companies doing and how are they incorporating international standards into their contracts. A neighbor of ours, American University, on January 17, 2012, issued a statement of social responsibility for American University business partners. And they state that AU expects business partners that enter into a written or licensing agreement with the institution to adhere to the following minimum standards of practice. And it goes on and it lists numerous standards. But specifically with regard to employment standards, it states, a business partner's employees should be present at work voluntarily in an environment which does not place them at an undue risk of physical harm, be fairly compensated, not exploited in any way, and then goes on to list about wages and benefits, regular working hours, overtime compensation, and for child labor, it states, business partners shall comply with the standards on child labor established by the ILO. And verification. If they find out that they're required, these partners, to use best efforts, and if it's found that a business partner should fail to comply with this statement, the university will seek mutually agreeable solutions and ultimately can terminate this business relationship. So again, the way that these are coming in. And the third would be, how is civil society, how are consumers holding this enforcement idea? And slaveryfootprint.org is one interesting example of that. It's a web and mobile-based application that allows users to understand how their lives may intersect with modern-day slavery. Nearly 3 million users in over 200 countries have accessed the website. The website was funded by the Department of State Trafficking Office. And it's a self-assessment tool that uses a way for consumers to identify how their own actions can drive markets for human trafficking. And it looks at a product score, for example. And it looks at the likely number of forced laborers that were used to produce those products. Slavery must be known to exist in a significant degree in that stage of the operation. So this is based on studies by the ILO, by the U.S., by intersection between the Department of Labor and ILO expert committees. It's also a source score. So they look at the probability that each source is produced in a country using slave labor. It looks at a manufacturing assembly score. It weights and measures and reports. And it uses a methodology that includes ILO standards. The other thing that's very interesting in that tool is it asks the question, do you buy sex? Which is a fairly provocative question. And it simply says, when you answer that question, it's not recorded in your score, but it says, if you do, you likely contribute exponentially to human sex trafficking, and gives you various sources to understand why that might be. So why we have laws against, and for U.S. contractors, the procurement of commercial sex, we see the human sex trafficking. This gets individuals to understand how their own actions may come into that. And once people, the idea also with Backpage of citizens, the NDAA, so the National District Attorneys Association, as well as Congress and the Senate and representatives are coming together, and they're asking Backpage to stop facilitating human trafficking, more specifically human sex trafficking, through their escort ads that quite often are for underage children, boys and girls, and that people are buying. And it comes to, can we put pressure as this international civil society on Congress to either say, when you looked at the Trafficking Victims Protection Act, it was intended to identify those that facilitate human trafficking, for example, like Backpage on its internet websites. And if that's not the intent, will you explore whether there should be legislation that addresses those issues? Currently, it's the Communication Decency Act prevents that from going on. I've gone over my time, I'm afraid, but I just wanted to rise some questions out about some of the activities that are being used at not just the level of existing laws, but how public pressure is being brought to maybe change those laws. Thank you.
So, thank you very much. So Michael's going to wrap it up, hopefully talking about a little bit about your former life with General Electric and how you had to deal with these as some of these issues of General Counsel.
Indeed. Let me start by saying that two aspects of my life have helped shape my thinking about today's topic. One is that I spent my legal career practicing international economic law. And secondly, I've spent the last 4 years since my retirement looking at the impact on that body of law of the Great Recession, from which we are even now struggling to recover. Rules arise from the attempt to prevent human tragedies in the future. I believe we are in one of the most important periods for the development of international economic law, with critical implications for how we should think about that law, including the world of international labor standards. I'm not an expert in international labor law, but as I said, I've been a practitioner of international economic law as a government official, as a lawyer in private practice, and 18 years, as Karen said, as senior counsel at General Electric, and finally now as a card-carrying member of civil society, a professor. I was born, incidentally, on the day the New York Times reported that the U.S. signed the General Agreement on Tariffs and Trade. So I represent the generation that grew up in the Bretton Woods bubble. Over the course of my legal career, I never questioned whether international economic law was law or whether it was relevant. For me, international economic law was always there to be used and developed to solve problems, mitigate risks, define and enforce rights and obligations, and address future contingencies. Trade and more recently finance have been my principal areas of interest, but I have addressed international labor rights, particularly as trade and labor rights have become more deeply enmeshed in rules, policies, and politics. At the outset, I'd like to raise a number of issues I think important to this discussion, some of which have already been mentioned. Are labor rights best addressed in the context of human rights or as linked to international trade rules? Are judges prepared for the complexity posed by claims of international labor rights, raising as they do unfamiliar legal issues, questions of economic policy, and challenges to the legitimacy and accountability of the sources of those claims? What impact has the Great Recession had on our view of international labor rights? And do labor rights advocates need to worry about regulatory failures in the international financial realm? In considering the role of the judiciary, what should we make of the trend in international economic law toward more formal, soft law rules that are increasingly important to international regulation, but intentionally constructed to avoid traditional adjudication in courts, even as they are becoming more enforceable by other means? And how are the forces of globalization transforming the context in which legal rights are understood, and what is the role of legal systems in securing the benefits of globalization while mitigating its costs and risks? American advocates of labor rights have had to contend with 2 points that have challenged their efforts to anchor U.S. law in international labor law: the complex relationship between the U.S. and the ILO, and the perceived lack of enforceability of ILO conventions. The U.S. did not join the ILO in 1919 when it was formed, and not until 1934, and dropped out of the ILO for a 3-year period from 1977 to 1980 in the heat of the Cold War, claiming the ILO was Soviet-dominated, applied double standards in its human rights activities. The United States has ratified only 14 of the 189 conventions of the ILO, 164 of which the ILO is currently promoting, including 2 of the 8 conventions that the ILO considers setting forth core labor standards. The failure to ratify the full panoply of ILO conventions reflects the fact that there are a number of ways in which U.S. law at the federal and state level depart from provisions of the conventions, and the inability of the advocates of those conventions to overcome the political resistance to changing those U.S. laws. The gap in this coverage, however, has been made up by the ILO Declaration on Fundamental Principles of Rights to Work in 1998. While not a convention, its legal authority comes from the fact that all members of the ILO by virtue of their membership, are required to give effect to the declarations. And it calls on all members to protect what are known as core labor standards: freedom of association, effective recognition of the right to collective bargaining, the elimination of all forms of forced and compulsory labor, the effective abolition of child labor, and the elimination of discrimination in respect of employment and occupation. This raises the whole question of hard law versus soft law, about which we could easily spend quite a lot of time today. International labor law is often characterized as soft law. Soft law is a term of art that has come to mean many things to many scholars and analysts. And here are some ways in which laws can be considered soft. The nature of the rules themselves, and whether they embody soft obligations, endeavor to, undertake to make best efforts, whether they are aspirational or hortatory, or are framed as principles that leave a lot of room for differences in application. The fact that they are not directly applicable, but must be translated into domestic law through national legislation, as is the case in most international agreements, as we've talked about. The lack of a mechanism or process to interpret the laws, the absence of an effective enforcement mechanism, and the source of the law as coming from national, international institutions or non-state actors in ways that call into question their legitimacy or accountability. Now, most advocates of labor rights are very critical of the ILO for its lack of enforcement authority, its inability or willingness to adopt sanctions for non-compliance, and its almost total dependence on education and persuasion as its principal operational tools. This criticism of the ILO and its conventions has led labor law advocates to pursue a two-pronged strategy: to seek enforcement of labor rights as human rights, and to link labor rights to the body of international trade law with its more highly developed system of rules, adjudication, and enforcement embodied in the World Trade Organization. I will skip over any discussion of human rights and come back to it when I talk about principles of conduct. Trade and labor have had an uneasy relationship at best since I started practicing. Starting in the late 1960s, labor unions led by the AFL-CIO went from supporters of international trade, as evidenced by their endorsement of the Kennedy round of trade negotiations, to opposition by the end of the Tokyo round in 1979. Over the next 30 years, labor unions have carried on a largely losing battle against U.S. participation in an ever-expanding network of bilateral and multilateral agreements, most recently those with Korea, Panama, and Colombia. Their opposition was not, however, for naught, because out of the political conflict has come a new set of rules that tie together international trade and labor rights and forms much of the content for the discussion we are going to have today. Debate over this link between fair labor standards and international trade goes back actually to the very origins of the trading system. We could talk about that, the Havana Charter, which, because the U.S. didn't approve the ITO, did not incorporate those provisions dealing with labor. The General Agreement on Tariffs and Trade had left them out, thinking the ITO would supersede the GATT. When it did not, the GATT, as a executive agreement that was never actually approved by Congress, actually became an international legal obligations of the United States, but left out the references to, except for some references to forced labor, prison labor, left out most of the provisions of the Havana Charter. And the U.S. Has been seeking unsuccessfully to remedy that omission ever since. There's a long story that I can go into about this effort, and Karen alluded to it, but basically it focused on incorporating basic fair labor standards: the right of association, the right to organize and bargain collectively, a prohibition on the use of any form of forced or compulsory labor, minimum age for the employment of children, and acceptable conditions of work on wages, hours, occupational safety, and health. But this linkage was opposed very strongly by developing countries that see it as a form of disguised protectionism and a threat to their economic development. We can talk about that. But there have been a number of approaches to deal with those opposition. I would summarize them this way. One, the conditionality approach. It's premised on the notion that it's perfectly appropriate to condition certain trade concessions on the beneficiary country's recognition of certain minimum international fair labor standards. Problems arise with the approach, however, when the standards contained in the conditions diverge from those of the beneficiary country as accepted or actually command international recognition. Unfair trade practice. This method involves the use of unfair trade practice laws to impose unilateral penalties against so-called social dumping. That is, the export of goods reflecting labor costs that are lower as a consequence of failure to uphold core labor standards. Again, it is opposed by developing countries, and it creates problems under the WTO, in particular, as cited in the famous tuna dolphin case, of going beyond the characteristics of the product to the production process methodologies as the basis for discrimination. This crosses, in the words of my colleague John Jackson, a bright line barrier against abuse that is the start of a slippery slope, one with very few handholds. The U.S. and Karen, actually it would be good to hear her try to remedy or raise the issue of worker rights in the Uruguay round. Again, it was unsuccessful except for a minor reference. Developing countries staunchly opposed the inclusion of a labor clause in the WTO, arguing that the ostensible expressions of social concern were simply a disguise for protectionism. More important problems, however, I think have arisen for advocates of labor and trade. The hard law regime of the WTO has hit the hard wall reality of an inability to formulate new international rules. That leaves us with a set of bilateral free trade agreements that at best provide a piecemeal approach and themselves have been hotly contested. Even as labor rights are integrating more closely with international trade, there is a larger dynamic at work that is transforming international trade as part of the larger field of international economic law. The forces behind this are the lessons, implications, and consequences of the Great Recession through which we have just lived and from which we are trying to recover. I have a lot that I'd like to talk about in terms of the Great Recession, but what I want to highlight is the way it has broken down, the way we have balkanized international economic law, with the trade people in their domain, the finance people in their domain, and the labor rights people trying to break in and link up to those various bodies of law. What the Great Recession showed us is issues of monetary policy, macroprudential supervision, international trade, and the well-being of workers are all in some ways linked in this whole globalization realm. The Great Recession has taught us, I think, one of the most important lessons, which comes from seeing how well the international trading system stood up to the crisis. There were concerns that it would collapse with a wave of protectionism, as happened in the 1930s, but it was avoided because the rules helped sustain the system. And the decline in trade was almost entirely a function of the fall-off in demand, not protectionist interventions. By contrast, we witnessed an almost total collapse of the financial system, due in significant part to regulatory failures. The collapse of the financial system has come with the most significant global economic decline since the Great Depression, and the implications of this global regulatory failure are consequential for all those who care about labor and trade. But what we're seeing in the financial area, and what has been the case, is a very different form of international law, a highly refined form of soft law, and I think in contrast to what we've heard about the origins of international law, let me read to you from a book that has just been published by one of my colleagues, Chris Brummer at Georgetown.
This book argues that in order to understand how soft law works in the global financial system, we need to examine broader institutional environment in which it operates. The book builds on long-standing insights from international law that soft law can have important advantages as a coordinating mechanism, but it breaks, on the other hand, with pervasive views that assume soft law to be necessarily non-binding. Instead, it argues that the degree to which an instrument is coercive or binding is less a matter of obligation than enforcement, where standards and best practices, even if informal, are backed by mechanisms that enforce compliance. They can be viewed from a functional standpoint as species of international law, albeit promulgated by means other than traditional treaty-making process. And here the book argues that international financial regulation, though not emanating from traditional authoritative sources, is indeed bolstered by a range of often complex enforcement technologies that render it more coercive than traditional theories of international law predict. There's a lot we can talk about, but I see I'm running out of time. I just want to highlight the code of conduct approach, because I think this is where labor rights comes together with human rights, international trade, and the emerging trends in international economic law coming from the international financial area. Companies view this linkage debate very different, but the more advanced thinking companies actually see the importance of protecting labor rights. They have adopted, as my former company, General Electric, statements on human rights policies, incorporating some of the, all of the principles of core labor standards, and they are educating their employees how to deal with these situations as they arise. And I personally was involved in one in Dubai, where a licensee, where a human rights organization challenged GE that was licensing a Universal Studios with accountability for the treatment of contractors that were hired to build this Universal Studios facility, even though we as a licensor don't really have any control over how our licensee might then deal with their contractors to build the facility. But because we had a relationship with the government and the people doing this operation, we were able to sit down, exchange our methodologies, our compliance system, and they were actually receptive and used those to incorporate them into their rule book and to develop a set of rules that dealt with some of those problems that you all may have read about in the construction area in Dubai. Let me conclude by an attempt to synthesize what I'm trying to say. I think we are at a timely point in history to rethink our views of international labor rights and how they fit into the fabric of international economic law. There is much to be learned about the character of law in this important field by studying the related fields of international trade and financial regulation. Our judiciary must be prepared to understand the issues from an historical, economic, and political perspective because of the complexity of the context in which cases and controversies are likely to arise. Of interest to all of us who aspire to advance the respect for core principles of fair labor standards is the most effective venue in which to advance those interests. In this respect, special attention deserves to be placed on the use of principles of conduct that can leverage the compliance systems, problem-solving capabilities, and supply chain relationships of responsible corporate citizens. Critical to the success of these efforts is the need to transcend the polarization that says my rights are absolute and paramount and any competing rights are simply the product of self-interest and corrupt manipulation of vulnerable political systems. I am hopeful that this conference can lay the groundwork for a new sense of cooperation and collaboration. The importance of this debate should not be underestimated. Although the global economy is recovering from the worst of the asset declines in housing, household wealth, and financial institution solvency, the question remains whether the global economy can recover in the absence of a greater sense of confidence among investors, consumers, employers, and employees, that comparable crises can be avoided or at least mitigated in the future. Moreover, can the global economy function properly when the systems of trade and finance seem so out of sync in terms of the quality of their regulatory frameworks and the strains that must be absorbed by one when the other fails to carry its weight in maintaining the stability of the overall system? Thank you.
So at the outset,
Let me just say, with the permission of everyone here, let's extend this session till 12:15 or 12:20. We're going to have lunch right outside the room, easily accessible, and I hate to just follow the exact schedule, but if people need to get up for different reasons, that's fine.
so what I was going to say, Nancy, instead of going back, and my colleagues can hate me for this, but instead of going back and giving everybody here an opportunity to say something else, I would like to open it up to all of you. I hate standing between you and lunch. And I also have, all of us have been in many, many of these conferences, and there are many, many of you out there who are experts. So I think what we need to do is open it up, and thank you for extending the time, Nancy, because I'm sure a lot of you have a number of questions. This is a broad, and I would say brilliant, panel, and they've put a lot of issues on the table. So if you could, as Nancy said before, just identify yourself when you ask questions, and I'll try to make sure this flows pretty well. So first question.
Thanks, Karen. George Dragnich. I'm a former executive director of the ILO, and thanks for a wonderful presentation. I wonder if you might just, all of you elaborated on the role of the executive branch in creating precedents. And Earl Brown specifically mentioned who governs the security forces at mine in Indonesia. I helped facilitate the negotiations for the voluntary principles governing extractive industries and energy. That was concluded in December of 2000. It was a joint U.S.-UK initiative. I was an American diplomat at the time. I was the U.S. Labor Council in London. This was not ad libitum on my part. I was acting under strict instructions from Washington. There's two of us, myself and the security chief at the U.S. Embassy in London. Karen, you may have been the one of those instructing us. It was very closely, tightly controlled by Washington. As I said, we did no ad libitum whatsoever. But what we helped was to facilitate all of the discussions, and this is the context, took place in a government building. They all took place at the FCO, the Foreign and Commonwealth Office. Secret negotiations and discussions between global unions, what would be the ICEM today, the International Chemical Engineering and Mining Confederation, its predecessors, from NGOs, and representatives from the extractive industries and energy. These were secret discussions because they were all non-binding. It wasn't secret once it was over, but there was definitely a government imprimatur. It was very clear. We were having every single meeting other than say maybe a Greek after work was held within the FCO premises. If you want to find out about the voluntary principles, I would suggest Google voluntary principles State Department, and it will take you to a State Department announcement in December 2000 when the voluntary principles were done. It clearly had the imprimatur of the U.S. government defined as the executive branch. Now, that happened a bit in the Clinton administration, but fast forward, I served as a senior officer in the Bureau of International Organization during the George Bush administration, and they were equally interventionists in terms of trafficking. They did great work. Could you please address the precedent that the executive branch could do?
So your question,
Well, to end, it could be Earl Brown, because he mentioned Indonesia. By the way, Indonesia was not in the room. We were all thinking about
but the question is, George, to articulate what is the importance of the executive branch, the role should be.
Does it have a legal precedent? I'm not a lawyer, but they are. If you're there and the U.S. government defines it as working with another foreign government, in this
So do those voluntary principles have a legal precedent?
Do they have, when you talk about customary law, do they clearly, as I said.
Earl, okay, I think we have Earl or Stephen. Who
Well,
wants to address it?
I think that
Shelby.
there's a broad issue of that. I'm not referencing a specific case, but there are principles for the treatment of security in extractive industries. I think those principles are an analog in labor and human rights to the soft law that Michael was referring to, and I think that the executive branch is often the platform for making those more and more binding. They're not binding in the sense of a justiciable judgment. There's nobody with contempt powers. But when the Amsterdam traders start laying down rules for commercial contracts, there was no court roaming the world enforcing those. They come out of the exigencies and they're binding because people have to abide by them. How successful they are in Indonesia is another question. You can look at the Exxon litigation and the settlements and the continued controversy over that issue in Papua and other places. But the work that Karen and you have done in the executive branch is one way that international law creeps back into domestic jurisdiction. So through trafficking law is a perfect example. Scalia may not want to look at it because it's foreign, but it's coming back in through executive orders, through assertions of extraterritoriality, through the simple construction of commercial agreements that have labor standards clauses and environmental clauses. So it's coming back in that way.
Any other comments from another question? Come on, I've given you time. Nancy, thank you.
So, Michael, what I understand that you were talking about in trade, what I want to say, our understanding is there are now about 25 years of trade agreements that have some labor conditions associated with them. And we are, at ILO, are studying what is the actual effect. And in these trade agreements, what we're seeing now fairly consistently is that any developed countries entering into trade agreements with any other countries always have labor conditions now. It's not just a United States phenomenon. And they have a fair amount of consistency in what the requirements are. However, I testified briefly before the Trade Committee by videotape last week of Canada's, the House of Commons Trade Committee, because they were getting ready to implement their Jordan free trade agreement between Jordan and Canada. And what I heard testimony by their trade negotiators is that people consider labor cooperative agreements or labor action plans to be in the third generation at this point in terms of how law is being created. And the example compared to NAFTA, for example, is that there are many layers of recourse for disputes all the way to the top, and it's still administrative primarily. Also, there are more clear penalties, including loss of trade preferences connected. And finally, there are more labor rights being recognized beyond, in the Canada one, for example, minimum wage and hours and migrant workers' protections are included in that agreement. And what the labor unions are saying now there is, does this matter? Is this having any impact? And that was what they were asking me. So it's something that ILO is working on all around the world, and I can say, certainly in the Middle East region, the countries where major labor rights advances are happening are the countries where there are trade agreements, about 4. But it's interesting because this is formal in some ways and soft, and I was wondering if you could comment on that a little more to help us understand. I understand how a code of conduct is soft and yet it's having broad effect. But this is also going into law and in more of a norm approach. So just wondered if you could comment more on that, or if Stephen or others might want to talk about it a little.
Shall I start? Let me just make 2 points.
One, by way of kind of illustrating your point, when I prepared my presentation, I went to one of my case books on international economic law by Andreas Lowenfeld, published just a few years ago. And I looked to see how labor rights are covered. 600-page textbook, nothing. I then went to Compa and Adelson and looked in their international labor rights and looked, and the largest section in their casebook is on labor rights and trade, and then another large section on principles of conduct. Lance tells me that similarly there's a human rights that has only 3 pages on labor rights. So there's clearly an evolution taking place that what I call this almost guild-like mentality of some of the conventional practitioners or even scholars are resisting. And this is where I think it's very important that we use discussions like this to break down some of that mindset. Because I think the point I would make is that those who would push forward on labor rights now have a greater panoply of tools to use. But there is no silver bullet. If a binding international agreement, binding international law would solve the problem, we would have solved the labor rights problem, we'd have solved the corruption problem, we would have facilitated, we wouldn't have any problem. The fact is that you need to see that as one of the tools in your toolkit. And I think creative use of these principles of conduct, because as you think about it, the footprint of companies that are embracing that, when you extend out through their supply chain, and you tie it to a strategy that uses all the tools that Earl and others can speak to of spotlighting, highlighting, mobilizing political support, using the courts to push enforceability as far as you can. All of that has to be part of the effort in order to accomplish it. To me, what is happening as we face into the reality of globalization and we come to look at it in a systemic way, what I think we're coming to realize is the more you can tie your rights into the functioning of the system as a whole, the more sources of leverage you've got, and the more commitment you have to any piece. Because even if a company, individual, government doesn't want to adhere to that piece, it fears what might happen to the system as a whole. That is the source of legal authority as we're coming to realize it. And that requires very creative approaches, different, I think, as this discussion has elucidated, from the very conventional kind of source-driven views of international law.
Go ahead, you first.
I was just going to add an interesting thought here, too, is innovative approaches to addressing this. While codes of conduct might be one way of getting companies because they want to do good business, another way is it is good business. People can choose where they buy now. That innovative idea of saying, listen, this is what they're doing. It's slave labor. It's what's going on. And there can be a tremendous consumer response to not purchase and to go someplace else. And I think that some of those tools that exist, there's a survey of products that are produced with child labor. And when that gets out there, people have a choice to say, well, I'm not going to buy from there. And sometimes that gets people to produce codes of conduct. And Marriott was caught in the sex trafficking issue. And now they're signatories to the code of conduct for commercial, for travel groups. And it's very interesting. They were pushed into it. Now they're being monitored. They're being closely watched because they've signed it. But I'm not sure they signed it out of the goodness of their heart. It was better business to sign it and now live up to it. You know what I mean? That sort of.
I'd just say that, often in conferences like this, I think, as a lawyer, as a practitioner for many years, that we are too often guilty of violating the old principle that when all you have is a hammer, everything looks like a nail. The fact is that if we were to set out this morning, if the task of this conference was to determine whether these international labor standards that we've now heard so much about this morning are hard law, enforceable in U.S. courts, brought in through a properly constitutional doorway into the United States District Court for the District of Idaho, if that's what we're looking for, then we might leave disappointed. But that isn't, as we've heard, that isn't the only measure of success of international labor standards, just as it isn't the only measure of success of international law in general. So even if the Supreme Court in Kyobel does the nasty on us and says that what happens overseas is none of the business of United States courts, and so on, and overturns a whole line of precedents starting with Gilartiga, even if that happens, that says nothing to the Supreme Court's use of international law in cases like Lawrence v. Texas, or in cases like Roper v. Simmons, the juvenile death penalty case, in which the Supreme Court held that the juvenile death penalty is inconsistent with emerging senses around the world, an emerging concept around the world that young people are not to be subjected to the ultimate criminal punishment. So what we're hearing here is, I think, that our vocabularies need to be expanded, our arsenals need to be expanded, and we need to be thinking not that we have lost if we can't answer the question, is this hard law that Judge Massetti has to apply in his courtroom? Even if the answer to that question is no, there are still plenty of ways to advocate for the adoption of international labor standards as governing principles within the United States, as a country, within private companies and their behavior, within international institutions, within civil society. The game isn't over, far from over.
Karen, may I make a comment on that?
Absolutely,
Follows
Judge.
on exactly what you just said. You know, first of all, codes of conduct, if it has language, this is voluntary only, you're out of court. There's nothing to talk about anymore. It might be a great statement, but that's all we need to trigger dismissal. The second point, we haven't talked about it all, is arbitration. That's where the courts are moving these days. And that's where you can incorporate standards. You've got corporations, people like Michael Gabon. They are willing to be rational, I think, and talk about what's reasonable under the circumstances. And maybe there's a dispute resolution mechanism that you can go to, where when you get these problems, they get resolved in an arbitration context. And there is binding arbitration. I mean, we can get that too for you, but the point of the matter is you can get a resolution that is not strictly legal, although it's binding, it's going to be enforceable when you come to court eventually. But that's where you can go, it seems to me. And that's really where the movement of the courts is right now. The courts are moving away from these standard combat and litigation posture to trying to put the cases out and get resolved that way. We haven't talked about arbitration, but it looms very large in the legal judicial context of the federal judiciary, of the state judiciaries now. So you need to think about that. That really is probably, in terms of enforcement, probably the most profitable angle that you could pursue. Or certainly more profitable than the straight litigation approach.
Thank
I
you.
agree with Steve 100%.
I wonder
Yeah,
if I
oh, go ahead.
Just to address your question, having attacked sovereignty and saying the federal judiciary is the last to know, I'm loath to say this, but now let me attack trade agreements and trade arguments, if you'll permit me. One of the areas I'm convinced, based on empirical, if anecdotal observation, is that one of the pressures against the downward spiral that globalization tends to induce is going to be young, Asian, aggressive, assertive workers striking companies where they have power. Really skillful, smart, intelligent, young Honda workers between 18 and 30 struck Honda in China in July of 2010 for 3 weeks, shut down the entire auto production chain globally, caused Honda's quarterly profits to tank. Honda makes 19% of its global profits in China, and collectively bargained oblivious to the Chinese courts, without the agency of the official trade union, and without any, but they actually called a law professor to help them negotiate, so law gets back in, but had nothing to do with trade agreements at all, but for a sense of who these workers were and their notions, not just of labor interests. They want more money, there's no question about it, but they also want decent hours, they want a social life, they want to marry who they want to marry. They have a notion of themselves that's rooted in human rights and not just labor rights. So they struck, and I think that is another element in this soft law mix. They're creating institutions of direct collective bargaining that would make the ILO thrilled, or should.
Well, and did you have an opinion about why the Chinese government allowed that? Well, we have a speculation.
What is your speculation?
Our speculation is that they know that salaries need to rise in China, and the middle class needs to develop for their economic reasons and their stability reasons. And I'm not speaking for the ILO, just a speculation that we've watched, and that's a very important economic trend.
Well, and I would agree with everything Earl says, except the part where he says this has nothing to do with international trade. I would argue this has everything to do with international trade.
Of course, it has to do with globalization.
We've got another question.
Dean Hubbard with Transport Workers and the National Union of Skilled Labor and Employment Committee. I was very intrigued by what Michael had to say about looking at the functioning of the system as a whole and gaining leverage through that. And I wanted to talk about what's been happening with respect to the case of the human rights of workers in Mexico who are members of independent unions as a possible case study. There's a very strong independent trade union movement in Mexico that's sort of resisting the tradition of corporatism and corrupt, what they call charro unions, that's really been under siege. And there's a fairly new tri-national solidarity alliance made up of trade unions from Canada, the U.S., and Mexico that are working in kind of a coordinated fashion in support of the independent unions and workers in Mexico on a number of different levels. There's been an international tribunal made up of preeminent practitioners and academics that's met in Mexico to look at some of these cases. There's been work done by the ICLR, the International Commission for Labor Rights, which Gene Weimer, who's here, founded, who was able to obtain a meeting with members of the Supreme Court. There have been cases filed with the ILO Committee on Freedom of Association. There have been actions carried out at Mexican consulates around the world. And then most recently, the filing by Mexican unions with the consultative offices established under NAFTA, under NAL, of complaints regarding the conduct of the Mexican government with respect to independent unions. And all of these things together, rather than any one kind of in isolation, seem to be beginning to have some impact. For example, the U.S. and Canada jointly, the consultative offices are apparently agreed to investigate the allegations and actually to set up an office in Mexico to begin to look at the issue. So I think it's a really compelling point that's being made about possibly the traditional way we think about litigation as sort of going into a state or a federal court, possibly being the last step that's taken, and that there are many other ways to leverage the system.
So one last question.
Allison Beck, I'm Deputy Director of the Federal Mediation Service with my colleague Eileen Hoffman, who has done a tremendous amount of international training for many, many years. I just want to comment on the point of the toolkit that Steve mentioned, and also Earl's point that the Hamas strikes were so successful. And just tell you a little bit about our experience with our international training programs at the Federal Mediation Service. We are finding now that there is more openness by the Labor Ministry in China, in Beijing, and in Vietnam to working with us to help establish conflict resolution systems, to work more on collective bargaining, meaningful collective bargaining. Of course, that remains to be seen in China. And as a result, the State Department, and as well as ILO, the Department of Labor, have been coming to us to help put programs into place very much the same as we evolved in the turn of the century in this country. Actually, Cindy Estlin has a great paper comparing what's going on in China now to what happened in this country. That, you know, with all of these labor disputes, it is in the economic interest of the multinationals doing business there to have dispute resolution, to have collective bargaining, and that necessarily brings ILO core standards into play. So again, it's just another tool. Our experience is that it seems to be, we have an opening with the rapidly developing market economies, and we'll see what happens.
Great, thank you. So it's almost 20 after, and I want to thank Stephen, Shelby, Earl, and Mike. And Nancy, marching orders are go out and grab something to eat.
Let me just say that there are lunches out in the atrium and tables, and we hope that this will be an opportunity for people to talk to each other on the subjects. And we'll be inviting you back in here for the plenary address by Janice Palacci, an actual former member of the ILO Experts Committee, who is going to talk to us about that, and as also